Your Honour, again, just a couple of procedural issues. At the beginning of the hearing this morning, Your Honour marked the blue folder as Exhibit 27.
29 it should be.
Yes, it's 29.
Yep.
Thank you.
My mistake.
And I also seek to tender another document, Your Honour. At the hearing on Friday, New South Wales Health Guidelines 6 was, one of the witnesses was taken to it, and the New South Wales Government has an updated version of that and would like it tendered, and I have copies of that here.
Very well, we'll make it 27:30. Thanks. Yes.
Right. I call Ms. Amanda Adrian.
You take an oath on the Bible or an affirmation?
Affirmation.
Would you repeat after me, please? I do solemnly, sincerely and truly
I do solemnly, sincerely and truly
declare and affirm
that
the evidence I shall give in this Royal Commission
the evidence I shall give in this Royal Commission
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the
and
truth.
nothing but the truth.
Thank you. Take a seat.
Thank you.
Here's Dr. Bennett.
Can you please tell the Commission your full name?
Yes, it's Amanda Mary Adrian.
And you're a former Commissioner of the Health Care Complaints Commission?
I am.
And what period did you hold that position?
From late June 2000 until December 2003.
And what position did you hold before that?
I was Director of the Private Healthcare Branch of New South Wales Health.
And what current position do you hold?
I am a sole practitioner in my own private practice.
Right. And what are your professional qualifications?
My professional qualifications are that I am a registered nurse, qualified in nursing, and have several nursing qualifications. I have a Bachelor of Arts degree and a Bachelor of Laws degree.
Now, Ms. Adrian, when you were at the Healthcare Complaints Commission, what was your, as the Commissioner, what was your day-to-day role in terms of the assessment and investigation of complaints?
In relation to the assessment of complaints, I chaired the Assessment Committee, which was a panel of senior officers and the medical director from the medical board in relation to medical complaints. So I saw all complaints at that point with their so the original documents that came through to the Commission, and a decision was made at that point.
Who made that actual final decision?
The final decision was usually after much discussion and looking at the documents available to us. It was my discretion to make that decision.
Right. And how many members were they of that committee?
It was a standard, just a working committee. Generally, it was those investigation team managers that were available. A legal officer would usually be there, and there would be the manager of the assessment team would be there because it was her or his group that were managing the incoming complaints. And there was often one of our clinical advisors there, if they were there.
And we've seen from the memorandums that are produced by the assessment officer that a recommendation is made by that officer to the assessment committee. Was that the usual practice? That
was when I first started, and it's certainly we moved to another practice during the time where we had and I think in the second matter we'll be talking about today, Mr. AWH, the assessment committee, that discretion was open usually, and for the panel to have discussion around and then a decision to be made.
Right. And so in the situation where before that practice occurred, was it often the case that the committee disagreed with the recommendation?
There were times when the recommendation was disagreed with. And that was usually drawing on the expertise of the members of that group.
And was that typically, that meeting with the assessment committee, was that typically the first contact you would have with that particular complaint?
In most cases, unless there'd been a particular matter that had come through via the inquiry service that was a cause for concern or needing advice in relation to that, but either the executive or myself would become involved.
Mm. And are you able to say, on average, how
needing advice in relation to that, but either the executive or myself would become involved.
Mm. And are you able to say, on average, how many of these assessments?
Probably sometimes within the realms of 25 to 30 matters would come before the assessment committee. I can't remember, I'm sorry, but it was a considerable number quite often. Probably sometimes within the realms of 25 to 30 matters would come before the assessment committee. And there were times when we actually had 2 meetings in a week because it was clear that we were unable to manage the load.
Right. And how long were those meetings?
Several hours. They usually went from, I think, about 9 a.m. until midday.
Mm-hmm. Right. Now, the second process that I'd like for you to describe for me is the investigation process. What was your day-to-day role, if any, in that process?
My day-to-day role, but it was in supporting the managers of the investigation team and the assistant commissioner, who was indeed the ultimate manager of those. I was often invited to case conferences where serious and concerning matters were then discussed. If there was some suggestion that we should take, for instance, go to the medical board with a recommendation that a Section 66 may be required, would be where.
Okay. So in a similar way, at the end of an investigation officer would produce a report with a recommendation?
It would be a consensus report that would have been developed in conjunction with the manager of the investigation team and the assistant commissioner or director, whichever era we're in. But so it would have been, the decision would have been made to make that recommendation with the support and input of those people. And quite often the reports would go back to the investigation officer if at each point there wasn't agreement that all matters had been investigated or all information contained in the report.
Right, so the committee would in fact have a look at the contents of the report, and if they weren't satisfied that certain issues had been investigated.
It wasn't a committee usually, it was the manager working with the investigation officer in the first instance, and then subsequently it would go to the next level, one of the executive member of staff who was responsible before it came to me. Right.
And again, the final decision in relation to what happens after an investigation lay with you?
Rested with me, but only after we had consulted with the medical board or the relevant health professional regulatory authority.
In terms of the qualifications of the people who were carrying out the investigations, how well trained in the law or otherwise were they?
The investigation officers, particularly, were a mix of. We had people with mixes of qualifications. We had people with clinical experience. We had a number of staff who had both clinical experience and policing experience. We had a number of lawyers who were working as investigation officers. So there was a very rich array of talent in that. And in the legal team, clearly there were solicitors practicing certificates.
Right. And are you able to say how many files and investigations
were solicitors practicing with the practicing certificates.
Right. And are you able to say
that I was there, because one of the deep concerns was that you can keep allocating files to somebody to the point where it's, you know, there is no capacity for them to manage it. So we had, and I think Professor Walton talked about some of the strategies where she got involved with active case management strategies to try and move some of the investigations on. I think Mr Pem in his statement suggested that sometimes investigation officers may have a caseload of up to 40 matters. That was totally unacceptable, but the other choice was not to allocate over that.
It bespeaks a lack of resource, is that what you're saying?
Well, there weren't enough people to manage the caseload that was within the Commission at that time.
That's a resource
yes,
issue.
It is.
Did you go to the government and ask for more?
I did. In the first instance, and you'll see from the annual reports that there was a steady increase to the allocation to the Commission in the time that I was there. And ultimately, the other resource that was clearly missing when I first arrived was the lack of the case management, technological case management system to support the decision-making and monitoring of the cases during the investigations and all the other complaint management strategies that we had.
Right. And is that you saying this, looking back now, you can see there was a lack of case management strategies, or was that something you were aware of?
That was something I identified almost immediately when I came to the office, was both the human resource issue and also the technology to support the caseload of the Commission.
Now, could I please have document behind tab number 359 put on the screen, please? There are a number of manuals and policy documents and directives and pieces of paper around the Healthcare Complaints Commission. At the time you were there. Now, here is a Healthcare Complaints Commission Practice Manual, volume number 3, and this manual relates specifically to investigations. Do you recognise that?
I do.
Covered, right. And if you could scroll down to the second page and just see the bottom of that second page, it says, reviewed in July 2001. So can you explain what this document is?
It was essentially a manual for investigation officers and the investigation team managers to assist them in both the policies and procedures of investigation at the Commission at that time.
Okay. Now, this is a version of the document that we have that was reviewed in July 2001, and we don't have a similar one for earlier times. Are you aware whether this document was created at this time or whether there had been previous versions?
Look, as far as I remember, there were documents that were single policy documents that we combined together to try and create a more coherent suite of policies and procedures within the Commission. And I'm not sure that there was the equivalent of that beforehand.
Okay.
I can't answer that, I don't know.
Yeah. Could I ask that we go to page 143 of that document, which is chapter 6. If you just look down the right-hand side of the page, right-hand bottom side is the page numbers. So that's page 168. If you could find the actual page number 143. Thank you. Now, in terms of this manual, what sort of training did the staff have in terms of understanding what its contents are and applying it in the everyday practice?
Certainly the investigation team managers and the director or subsequently the assistant commissioner did organise a number of, when the document was introduced, a number of workshops, and it certainly, as I said, had come from business and the legislation, so it wasn't a totally new document. Certainly it was part of an orientation to the Commission. It would be part of a package of information that would be given to a new investigations officer.
Right, okay. If you look down, so this is Chapter 6, which is the guidelines on complaints of sexual assault, etc. And if you look down at Part 6.1, the introduction, it says that people who report incidents of sexual assault, harassment or inappropriate sexual relationships with health providers have special needs and require a sensitive and supportive response from the investigator dealing with the matter. This support is usually required throughout the investigative and disciplinary process. What sort of ongoing support and training did staff members have in terms of being able to carry that out at a day-to-day coalface level?
From memory, and this is from memory, we did have regular ongoing staff development for staff. The patient support officer at that time had some very skilled senior officers who were welfare workers, who had been social workers, who dealt with matters like this, who were certainly involved in the providing support where they could in these areas. And so there were workshops and things. The specificity of a program, there was a program that the director of the patient support office had, because they had the responsibility for that professional development for the staff.
Okay. Now, could I ask that we scroll down to page 151 of that document, and that's to part 6.9. Thank you. There's a subheading here, focus of investigation, and sets out various things to have a look at. Now, the first one there is to obtain a statutory declaration from the complainant. Now, that's in terms of the statutory requirements of the prosecution of a complaint. That's a requirement there.
It was an absolute requirement in the at the time that I was Commissioner, Section 23.
Now, the second bullet point there says, interview anyone the complainant may have told about the incidents and those people who are in close proximity at the time. So that's an expectation of the legal officers who are carrying out an investigation. Is that right? Similarly, bullet point 3 there is obtain corroborative material, and that will include medical records, documents, receipts, diaries, etc.
Yes.
And again, that's an expectation at the time of the investigation. Now, again, the fourth one is obtain a criminal history on the identified practitioner if warranted.
Yes.
Okay. So in this sort of situation, again, this is because it relates to sexual assault. The investigation officer's mind is alert to the fact that if there's an allegation of current criminal activity, there's potential for past criminal activity also.
Yes.
Now, at the bottom of that page is 6.10, and that relates to corroborating evidence. And it sets out in a little more detail what's referred to above about the sort of evidence that an investigation officer might obtain. And again, the first dot point there being evidence from witnesses that the patient complained to them, etc., shortly after it happened. Now, the second dot point is evidence of opportunity. Can you give a bit more explanation of what is meant by that?
Well, I can only assume that it goes to the fact that the medical practitioner or the health practitioner met with the client alone, that sort of thing. Mm-hmm. There was no chaperone, no parent, no partner at the consultational point of contact.
Okay, and another dot point there, the medical condition of the complainant, that's something that the investigation officer ought to have regard to.
Yes.
The distressed condition of the complainant at the relevant times.
Yes.
And would that also include the distress of the complainant at the time of, in fact, making the allegations also?
Absolutely.
And also the lies told by the identified practitioner.
Yes.
Yeah. Now, underneath that is 6.11, and this refers to contact with the police. Now, in the first paragraph there, it says certain types of sexual conduct constitute offences under the Crimes Act. And the second paragraph says complainants should always be advised that they can report the matter to the police.
Yes.
Now, look, it was your understanding from the time that you were the Commissioner that that is in fact something that the investigators ought to have done in every single case.
And I think, as Professor Walton said, it was often discussed at the assessment committees.
The next paragraph says, sexual assault is a crime and generally speaking should be dealt with as such. If a person is reluctant to go to the police, this wish must be respected. However, it should be pointed out to the persons concerned that, and there are a number of issues here, and these are issues that ought to be put to the complainant, that if the alleged offender is not registered under any Health Registration Act in New South Wales, there is nothing the Commission can do.
At that time.
At that time. And secondly, if the person is convicted of sexual assault, they can go to jail. The Registration Acts are limited in relation to penalties, i.e. deregistration.
Yes.
So the expectation there is that an investigation officer or one of the officers ought to be telling the complainants exactly what the Healthcare Complaints Commission cannot do.
Yes.
And perhaps making the distinction between what the Healthcare Complaints Commission can do and what the criminal justice system can do.
Yes.
And lastly, just some reassurance here, going to the police need not be a traumatic experience in itself.
Yes.
Are the investigation officers expected to know enough about the police system to be able to give this reassurance to the complainant?
As I said earlier, I think a number of our investigation officers did have police experience and had been policemen on women before they came to the Commission.
Mm-hmm. Now, the paragraph underneath that is the Commission should not discourage people from going to the police or seeking legal advice.
Yes.
Mm-hmm. Now, Ms Adrian, you were provided with a statement of AWC, who gave evidence in the Royal Commission before now. And you understand that in that statement he set out his experiences of child sexual abuse, but also his experiences of reporting that abuse to the Healthcare Complaints Commission. Now, you've read that statement.
I have.
Mm-hmm. And you're aware that the second part of the investigation of that complaint occurred during the time when you were the Commissioner of the Healthcare Complaints Commission. Now, could I please have the statement of AWC on the screen, please? Now, Ms Adrian, you were here in the room this morning and you heard the evidence from Professor Walton. So I won't take you through the context, and can I assume that you understand that the steps that were taken in the investigation of AWC's complaint up until the point where you became the Commissioner? Yes. Now, it was in September 1999 that Dr Rolleston was sent a letter from the Commission setting out the substance of the complaint made and a request was, a response was sought from Dr. Rolleston. Now, at tab 41 of the tender bundle is the response that was received from Dr. Rolleston's legal advisors. And if that document could be on the screen, please. Tab 41. You can see in the top left-hand corner is the 6th of June. So this is the month you've started as Commissioner. Perhaps you started at the end of June.
I did.
But just to give the context of where we're at here, if you scroll further down the page there, you can see on the right there that this is a letter from the United Medical Protection, and they're advising the Healthcare Complaints Commission. In that first paragraph there, I refer to the matter and advise you I will be assisting Dr. Rolleston with the complaint against him by Mr. AWC. And then in the next paragraph, he seeks an extension of the time. He says he'll be meeting with Dr. Rolleston on the 9th of June. A response to your letter dated the 1st of May will be made within 14 days of that date. And lastly, once again here, it states that Dr. Rolleston now resides and practices at Broken Hill.
Yes.
And this is a complaint of a very serious criminal offence. It's a complaint against of child sexual abuse.
Yes.
And it's a complaint now where the Healthcare Complaints Commission is fully aware the practitioner is continuing to practice in Broken Hill. Looking back now at this particular point in time, which is when you came into it, what is your view on whether or not a referral ought to have been made to the police?
I totally agree that Mr. AWC should have been counselled to attend the police.
Mm-hmm. Now, if I could have document behind tab 42. And again, this is another letter from the legal advisors of Dr. Rolleston. It's dated the 22nd of June. And in this letter, in the first paragraph, it refers to the of Dr. Rolleston. It's dated the 22nd of June. And in this letter, now in the first paragraph, the second paragraph there, it's confirmed that in 1979 that Dr. Rolleston was indeed working as a general practitioner in St Ives and also at the Royal North Shore Hospital. Yes. So that information is confirmed. And in the fourth paragraph there, the Healthcare Complaints Hospital. Yes. So that information is confirmed. And in the way improperly towards the patient, and he denies having acted in the matter alleged.
Yes.
I'd imagine that is the usual type of response that the Healthcare Complaints Commission issued, and he denies having acted in the matter alleged.
Yes.
I'd imagine that is...
Professor Walton referred to that this morning. It was a standard response.
That's right. Now, I take you to paragraph 5 there, and it's where the legal representatives of Dr. Rolleston are making a submission to the Healthcare Complaints Commission. They say, "We submit that your commission should not proceed on this complaint. As a result of the very lengthy delay in bringing this complaint, Dr. Rolleston is now placed in an impossible position in which to defend himself. As indicated, he has no recollection of the consultation complaint. Dr. Rolleston is now placed in an impossible position in which to defend himself. Members were on duty at the time in question. It would appear that there are no persons who the complainant made a contemporaneous complaint to. They conclude it would be invidious in our submission for your commission to proceed further with this matter."
Yes.
So that's in June. Now, the next document we have in relation to the handling of this complaint is a document behind 43 of the tender bundle. Could I have that document on the screen, please? Now, this is a file note by an officer of the Healthcare Complaints Commission. And in fact, I might get you to scroll down to the second page of this document because it's the transcription of this writing, which is a little hard to read. And keep scrolling down a little bit further, please. Right, you can stop there. Now, bearing in mind that this complaint was made in August of 1998, and this file note is made in July 2001. So the Commission has been investigating this, or has had it in its possession for some 3 years here. Now, to be fair, at the top of that note there, and we've just missed out, it says apologised for length of time in investigating case. But certainly not much has happened. Finally, the Healthcare Complaints Commission gets a response from the practitioner in that letter dated the 22nd of June, and this is the first documentation of what it is the Healthcare Complaints Commission makes of that response. If you scroll down to the bottom there, this is a telephone call between the officer of the Healthcare Complaints Commission and Mr. AWC. He is advised, 1, doctor can apply for a stay of proceedings due to the delay. 2, difficult to prove even with a credible witness due to delay and loss of memory of witness and doctor. 3, lack of corroboration, ? And then there's the indication that it's going to be addressed in an investigation report. This investigation officer who has called Mr. AWC has pretty much adopted the submissions made the month before by the practitioner, hasn't he? Or she, hasn't she?
It would seem so, yes.
That's fairly extraordinary, don't you think, after having this case and investigating that case for 3 years, to immediately adopt the submissions made by the practitioner?
Yes.
Now, the next documentation in relation to the handling of AWC's matter is in another file note behind tab 45. Now, if you just scroll down to the bottom so you can see the date is the 12th of September 2001.
Yes.
And if we can go to the top of that document once again, the file note is written to David, and I'd imagine that was David.
Mr. Swain.
Yes, that's right. Now, what's said is we can, if we want, to refer the matter to the DPP. I believe our practice in the past has been to make such a referral when we believe the matter may warrant institution of a prosecution based on our investigation. Now, a few things are said there in the middle of the paragraph, but down towards the end there, from about the fourth last line, this legal officer has said, I suggest the victim be contacted and told where we are at, explain we have the option of referring to DPP and ask him what his views are. He may have already reported it to the police. The file doesn't say. If he wants us to refer it to the DPP, then we should. If he does, then we should. If he doesn't, I'm not sure why we would wish to refer it. Now, there is no evidence in these records that that was ever done, is it?
No.
Have you got any idea of why that would be?
I have no memory of this particular case. However, it is clearly outlined in our Act at the end of an investigation. One of the options available to the Commission is to refer the matter to the Director of Public Prosecutions.
Right. And looking at that now, do you consider that regrettable?
Yes, absolutely.
Could I have the document behind tab 47 of the tender bundle, please? Now, this is an investigation report. That last file note was from the 12th of September, and this is an investigation report dated the 28th of September 2001, so certainly soon after that. Now, it's a 7-page investigation report, so I might just ask that we scroll down to page 7 of that report. Now, and just a little bit further, please. Yes, you can stop there. Now, this investigation report, who does this report go to?
The investigation report in this particular case would have been drafted by in this particular case, unusually, because it was a serious matter, it was managed within the legal team. Mm-hmm. It would have gone to the Director of Investigations and Complaints, who was a senior legal officer after Mr Swain had drafted it, and then it would have come to me. But as I say, there could have been some back and forward before that, right, which I wouldn't have seen necessarily.
Now, on this final page of the document, there's a paragraph there that starts, "The Commission has carefully considered the information obtained during the investigation and the legal position and has decided to terminate the matter pursuant to Section 39(1)(e) of the Healthcare Complaints Act and not to institute disciplinary proceedings for the following reasons." Now, are you able to tell us what Section 39, subsection 1(e) of the Act is?
At that time, it was terminate the matter.
Mm-hmm. And when it sets out that provision, it's simply the power to terminate.
Yes.
Mm-hmm. Now, it's
terminate the matter.
Mm-hmm. And when it sets out that provision, it's simply behind the decision to terminate. Now, the first one there is the alleged misconduct occurred in 1979, and it's stated that's 22 years ago. Now, of course, you recognise that, in fact, when it first came to the Healthcare Complaints Commission, it was only a 19-year complaint.
Yes.
Now, the second dot point is there was a significant delay in the making of the complaint, which places the practitioner in a prejudicial position. Now, tackling the first part of that first of all, there clearly was a delay in the making of the complaint, but you having had regard to the nature of the complaint, are you of the opinion that it's entirely explainable why there was a delay?
Yes.
Now, in terms of this being one of the reasons for terminating this complaint, do you consider that the weight that's been given to the prejudice to the practitioner appropriate?
No, I don't.
The next dot point says, after 22 years, there is no longer public interest in taking disciplinary action. Do you agree with that?
No.
Can you just explain exactly what it is that might have been meant by public interest in this situation?
As I say, I have no memory of the matter, but the argument that may have been put that there had been no further conduct of that doctor that we knew of at that time, that would warrant, that there had been nothing else come forward. I can only speculate.
Mm. And that's in the context of this practitioner still practising and no doubt still having access to children.
Yes.
And again, looking back at this now, do you agree? You don't agree with that?
I don't agree with this.
The next point is that there have been no other complaints of this nature against Dr. Rolleston. But it's true, isn't it, that there were very serious fraud and dishonesty complaints in relation to Dr. Rolleston.
Which would have been one of the matters that we would have taken into consideration.
Yes.
Yes.
It's also the case, isn't it, that if the Healthcare Complaints Commission has never shared information with the police or referred the matter to the police, the Healthcare Complaints Commission is in no position to know whether other complaints have been made to the police.
That's the case.
The last dot point there is that the difficulties in proving the complaint of professional misconduct, given the lack of corroborative evidence, and I'll stop there first of all. Now, in terms of corroborative evidence, the investigation officer who has put this particular report together, it would not appear from the documents, has not obtained any witness statements, for example, from anybody else besides AWC.
It's certainly not on the face of this document.
So, in fact, that there is no corroborative evidence as set out here isn't because there isn't any.
No.
And the second part of that sentence, the denial of the misconduct by Dr. Rolleston, well, everybody, and we've said beforehand, is simply the second part of that sentence, the denial of the misconduct by Dr. Rolleston, have any place in a consideration of whether a complaint should be terminated. No. The last paragraph there, following those dot points, says that the Commission's considered referring the complaint to the Director of Public Prosecutions and also the Department of Community Services because it involved alleged criminal conduct of a young person. So yes, the Commission's turned its mind to that. However, has decided not to refer the complaint to these allegations for the same reasons it has decided to terminate the matter.
Yes.
So those matters under the dot points there. Looking back at that decision-making now, that decision and that decision-making, do you stand by that decision?
No, I don't. I see that it was flawed. Mm-hmm. And, however, the further advice that comes in that report is, I consider, was part of the decision-making process. That the advice from the legal team was that the precedents and conduct of the tribunal in matters such as this would mean that it would be unsuccessful.
Mm-hmm. So are you saying that when your final decision-making takes place, you are in fact quite heavily reliant upon what it is that the investigation officer has set out in terms of precedents?
Yes, and it would have been, and while I have no memory of this particular matter, these serious matters would have been a matter for case conferences and discussion about such advice, and I certainly would have read the precedent matter information. Mm-hmm.
Now, on the same day as the date of that report, Mr. Swain also made a telephone call to AWC, and the file note that relates to that telephone call is behind tab 48. Now here the officer says that there was a telephone attendance on the 28th of September there, and if you go down to the third line there, the legal officer has said, and this is his file note of his conversation with AWC, I said I would be recommending that no action be taken given the age of the incident. There is no longer a public interest in pursuing it after such a long time, and there'd been no other complaints of this nature to Dr. Rolleston. Again, in saying to a complainant that there is no public interest in pursuing this complaint, do you consider that an appropriate thing for this legal officer to be saying to the complainant? No. Now, in the second paragraph of that file note, and the officer has said, referring to Mr AWC, he said that if no action was going to be taken, he was going to go to a private solicitor and take civil action. He was awaiting the outcome of what the Commission was going to do. I said I would also be recommending that the complaint not be referred to the police or the Department of Community Services for the same reasons outlined above and the difficulties in proof. Now, and then he says, I asked if he had considered going to the police and he said he might and wanted to know why it would not be referred. I again stated the reasons. Now, doesn't that amount to discouraging AWC from going to the police?
Yes.
And that's certainly in complete disregard to the policy that the Healthcare Complaints Commission had in place at the time.
It is.
At paragraph 86 of AWC's statement, he said, on or around the 17th of November 2001, I received a letter from the HCCC Commissioner, Amanda Adrian, informing me that the HCCC had decided to terminate my complaint. It was deeply disappointing and annoying decision. I felt the HCCC had been useless for the past few years in investigating Dr. Rolleston and then had proceeded to terminate my complaint. Now, given the documents you've been taken to, Ms Adrian, do you consider that this is a fair comment from AWC?
I do, and I acknowledge that the actions of terminating the complaint would have been met by Mr AWC as incomprehensible and contemptuous by the Commission. Mr AWC came to the Commission seeking remedy after a long time for a matter that obviously was cause of great damage, harm and emotional horror. And we failed him. And I apologise for that on my watch.
Ms Adrian, did you appreciate at the time that many people in the position of AWC have difficulty in reporting their abuse for many years?
I think most of the officers at the Commission, including myself, did recognise that that was a pattern of a normal situation because it was such a difficult time.
It doesn't seem that the legal officer who prepared the report really appreciated that.
I agree with you.
Secondly, did you appreciate that the police have investigative methods that you didn't have available to you?
Yes.
In relation to a case such as this?
Yes. And I think Professor Walton this morning expressed some of the difficulties we had with the police who at that time, and I know that's not the case so much now, but at that time would require us to close our investigation down and hand over all of our material.
Well, given that the officer was recommending that you close down your investigation, did it occur to you that in fact, in the circumstances that you were presented with, that indeed it may be that the police had the capacity to do what you couldn't do, and that is establish the complaint beyond any doubt?
I have no memory of my decision at that time, I'm sorry, and what was the source of not making that call.
But looking back now, did you not understand that the police had methods that you didn't have that may have enabled them to establish the complaint beyond any doubt?
Yes.
You did?
I do, and did.
But you don't know whether you brought them to mind at the time?
No, I didn't. I don't remember that because I have no memory of this particular case. However, I think the officer at this stage saying that he was going to suggest that we didn't refer it. We didn't refer it. However, he does say he asked Mr. AWC if he was going to take it himself to the police.
Before Mr. AWC would have any true understanding of what that might mean, he'd need to have explained to him what the police might be able to do, wouldn't he?
Yes, and I would have hoped that the staff dealing with this matter, the investigation staff, the legal staff, would have explained that to him.
Well, look, on that point then I might just get the document behind tab 48 on the screen again, because... And down to the middle of that second paragraph there, you see what's happened is this legal officer, and I make the note that at the very bottom of the page, all of what took place in these paragraphs happened in 5 minutes. So his file noted this is a 5-minute conversation to let Mr. AWC know that the Healthcare Complaints Commission is terminating his complaint. So here in the middle of the second paragraph there, he says, I said I would also be recommending that the complaint not be referred to the police or the Department of Community Services for the same reasons above and the difficulties in proof. Now, then he says, I asked if he'd considered going to the police. He said he might. So there's a little glimmer there still left in him that he might do something. And wanted to know why it would not be referred. So throw me something, please, to encourage me. Now, this legal officer says, I again stated the reasons.
Yes.
So there was a little glimmer there, a little opportunity for this legal officer to say, listen, the police have a whole suite of powers and skills that we don't have.
Yes.
Please go there. And that opportunity was entirely crushed.
Yes.
Ms Adrian, you're aware that Mr Pem, who's the current Commissioner of the Healthcare Complaints Commission, gave evidence in these proceedings last week. Now, he was asked about the delay issue in relation to the assessment and the investigation of AWC's complaint. So I took him to the various documents that have been produced by the Healthcare Complaints Commission. And Mr Pem stated that when he arrived at the Commission in 2004, that it was not uncommon to see delays of 2 and 3 years in files between any action being taken. Now, do you have any recollection of delays in action being taken during your watch?
Certainly the number of investigations underway and the caseload was enormous. And we were working on various strategies, continuing on from the work that Professor Walton had done to try and wrestle those down within the resources. The number of matters, and I think I've said earlier, it wasn't just about loading more and more cases onto officers, and was how there could be other ways of dealing with those matters. Certainly when I left the Commission in December 2003, that wasn't the case, that the number of delays and the number of long investigations had diminished substantially. However, there still were some matters that were taking longer than they should have for various reasons.
Ms Adrian, the picture which the Commissioner and I have at the moment is that during your time and when you left, there was a significant lack of capacity in the Commission to deal efficiently with complaints. Now, is that a wrong impression or is that correct?
It's certainly the resources of both the technological and the human resources available to the Commission was not commensurate with the caseload that we had. And during my time at the Commission, I did, through the budget process, seek further funding for both those resource needs. I sought and received funding for a case management system, and that was tendered for and The development was well underway when I left the Commission in 2003, and that's the casemate system, which I understand was fully operational in 2005, but the development was well underway when I left. We had developed, through the time that I was at the Commission, a much more active manual case management system because the database wasn't adequate for the business that we had, and that ultimately fed into the design of the technology that Casemate had.
That hasn't quite answered my question. I asked you whether there was a significant lack of capacity in the Commission to deal effectively with complaints during your time and at the time you left. Now, that's the impression we have.
Yes,
is
and
it
I
a
think
correct impression to have?
It is a correct impression to have, and I think you'll find that on my after I was left the Commission, that substantial additional funding was provided to the Commission.
Now, given that lack of capacity and therefore lack of efficiency, did you institute a system which ensured that critical matters or the more serious complaints were accelerated through the process of the Commission?
Yes, we did develop a prioritisation system, but it was a manual system, so the monitoring of it was very difficult, Your Honour. It was very much the managers of each of the investigation teams and the legal team reporting up through the Assistant Commissioners and to myself about what matters were underway. The milestones and management of those cases was all manual. There was no mechanism to monitor that automatically. But there was, by the time that I left, a very efficient system of spreadsheets and mechanisms for managing that.
The critical issue, though, is when something came in the door or came by telephone, that there was someone who had the capacity to say, this is serious.
Yes.
This needs to be accelerated. Now, did you have that sort of management capacity?
Yes, we did.
What was it? How was it done?
The Patient Support Office managed the patient inquiry component of the business with the assessment team, and if the assessment team had to automatically hand over a telephone inquiry that came in along those lines to a more senior officer to deal with that matter. And I think in relation to both of the matters here, the Commission immediately saw the importance and the seriousness of the conduct in relation to these two matters.
Sorry, you say that you believe the Commission immediately saw the significance of these complaints?
The fact that they escalated certainly Mr AWC's complaint to investigation, and
that you believe the Commission immediately saw the significance of these complaints?
The fact that they escalated complaint by seeking a statutory declaration means that there was a recognition of the seriousness and nature of those complaints that would ultimately and should ultimately go to prosecution.
Well, given the length of time it took to deal with AWC's complaint after you say it was recognised as being serious, that does not fill the Commission and I with confidence
I can understand
that the Commission was functioning effectively. What do you say to that?
Yes, I agree with you on the face of that particular complaint. That's the case.
Should we assume that there would be other problems during that time that have affected other complainants?
There were other matters that were delayed at that time, and we were very aware of those, and we were actively seeking mechanisms to manage those. And certainly the Assistant Commissioners and the managers of each of the teams were working with me closely to try and look at ways that we could use the resources we had to manage and prioritise those matters. And I wouldn't say there were a large number of serious complaints that were dealt with in this way.
Now, during our time in the Royal Commission, we've learnt of the experience of those who have had to look at complaints of this nature, which tells you that in many cases, if there's one offence, one transgression of this type, it's very likely there'll be others.
Yes.
Now, did you understand that at the time that you were the Commissioner of the Complaints Commission?
Certainly in relation to the sexual assault matters, yes, I think there was a general understanding that that could be the case.
That meant that if the allegation was true, there was a medical practitioner who was still practising and had been for many years in circumstances where, if the allegation was true, you could assume that there would be other victims.
Yes. However, we had no evidence of that at that time.
You had no evidence of it, but that was an assumption that it was reasonable to make if the allegation was true, wasn't it?
Yes.
Did that suggest to you that this was an allegation which needed the highest priority?
Certainly matters of this type were matters that the Commission took very seriously and considered that. But I have no, as I say, I have no memory of this particular matter and what I knew of it at that time.
Again, would you accept that the documents that we've been able to look at don't suggest that what you indicate should have happened actually did happen?
Yes.
This was not given the priority, it was not given the seriousness that it should have had.
And that's on the face of the documents, yes.
Yeah.
Mm-hmm. Ms Adrian, I'd taken you to some of the evidence that Mr Pem gave last week, and I'll just take you back to that before the lunch adjournment. In addition to Mr Pem had been asked about the period when he came to the Commission in 2004. Now, he said at the time that there were a great many allocated files around at this time, and he specifically said, and this is at the transcript 14185, well, they were actually piled up in a big corner office. There were probably 700 or 800 files that were unallocated. Now, to that, His Honour asked, over what period of time had they been accumulating? And Mr Pem said, probably 3 or 4 years. I think that it seemed that the Commission there was too much work, and the investigation officers decided they would have a limit on the number of files they took, and those that weren't seemed that the Commission there was too much work, and the investigation officers decided they would have a limit on the number of files they took, and those that weren't, if their file limit was exceeded, they laid fallow. Would you like to make a comment on that evidence?
I would find that highly improbable. I would say at the end of 2003 that was not the case. Files were actively managed, and the Assistant Commissioner for Complaint Resolution at that time had a very active process of working with the investigation managers to ensure that files were prioritised and allocated where they could be. I would find that improbable. That it certainly was not the case when I left the Commission in December 2003.
Was there electronically, what was the allocation system? Was it literally, here is somebody's file, and the allocation system process was that file landed on that desk and that's how it got allocated?
No, it wasn't. It was the Assistant Commissioner would review the file and look at the caseload of work with the manager of the investigation teams, because there was a strong team structure in the Commission at that time, and they would look at the priority and the seriousness of matters and allocate those that were likely to go to prosecution and were of a serious nature, such as sexual assault, the serious clinical events and things like that. They would allocate those immediately. Mm-hmm. That was, as I said, managed through a manual system of setting milestones with the investigation team around what would be expected to happen by when.
Okay. Now, Ms Adrian, you've also been provided with a statement of AWH in these proceedings. And again, you understand he's given evidence in these proceedings as to his experience of reporting the allegations to the Healthcare Complaints Commission. Now, could you go to paragraph 20 of that statement, please? Now, AWH says, I came across the HCCC in or about 2003. And my email said my brother, sister and I had been assaulted at the St Ives practice because, as previously stated, I knew, and then he states his brother's name there, which is AWO in these proceedings, and I had been abused and I suspected the same had occurred to my sister. And of course, he says, with the benefit of hindsight, I note that that suspicion about my sister being abused by Dr. Rolleston was incorrect. So again, this is a complaint where, from the commencement of the complaint, that the Healthcare Complaints Commission is precisely aware of the doctor's name, precisely aware of the place that the alleged child sexual abuse took place. Now, later on down in paragraph 25, there is communication between AWH and the Healthcare Complaints Commission. On the 23rd of May, I received a further email from Ms Jones, and she advised she'd been able to identify Dr Rolleston and that his complaint was to be assessed next week. Now, could I have the document behind tab 60 on the screen, please? To the suggestion that his complaint will be assessed next week, he writes back, I'm now so very happy. It's the top paragraph there. I'm so very happy. Regardless of your outcomes, I feel totally refreshed simply by the fact that after all these years, I've had the guts to open my closet and get it off my chest. And in this, AWH is letting the Healthcare Complaints Commission know that this is the opportunity that he's finally found. He's found the courage to come to the Healthcare Complaints Commission. Yes. Now, what he says in the middle of this paragraph is, if anything is to come of my complaint, I'll be willing to go to whatever extremes you want to see that maybe some small token of justice is done. Now, he's mentioned small token of justice here, and in terms of any of the documents at this point of the assessment or early part of the investigation, there's no suggestion that anybody has had a conversation with AWH that, whilst the Healthcare Complaints Commission is one option in relation to making a complaint, the other options one of the other options is to go to the police.
Certainly on the documents today, no.
And again, having regard to the Commission's policy that was in place at the time, it's clear from the terms of the complaint that this is a serious sexual misconduct of the doctor that's being alleged. And in compliance with the policy sooner rather than later, it ought to have been pointed out to Mr AWH that, in fact, it would be appropriate for him to take his complaint to the police as well.
Yes.
And that didn't happen.
Certainly documented.
WH, that, in fact, it would be appropriate for him to take his complaint to the police.